Today's podcast is on California lobbying, and actually, it's a quiz to test your knowledge about California's lobbying laws. So, the first question is procurement lobbying of state agencies and departments is regulated under the FPPC like other forms of lobbying. That's false because procurement lobbying does not require registration as a lobbyist per instructions by the FPPC. Question two, quasi-legislative and quasi-judicial activities at state agencies and departments are reportable lobbying activities. That's false. Only quasi-legislative or the rulemaking or the regulatory activities, those proceedings, those are reportable activities as a lobbyist. Question three, registered lobbyists must take an ethics course every 2-year legislative session. That is true. Question four, the prohibition of giving a gift of more than $10 per calendar month applies to both lobbyists and lobbyist employers. That's false. The $10 gift rule only applies to registered lobbyists and lobbying firms. Question five, like their federal counterparts, registered lobbyists in California can use contingency fee agreements with their clients. That's false. Contingency fee agreements are prohibited by state law, but they are allowed at the federal level. Question six, 3 types of persons are required to register with the Secretary of State under the Political Reform Act. That's true. They are lobbying firms, lobbyist employers, and lobbying coalitions. Question seven, issue lobbying advertisements are regulated by the Political Reform Act. That's true. It's section 86119 of the Government Code. Question eight, a lobbyist is prohibited from attempting to deceive any legislative official regarding material facts on pending legislation. That's true pursuant to Government Code section 86205. Question nine, a lobbyist can cause a bill to be introduced and then be employed to secure the bill's passage or defeat. That is false. This activity is prohibited under state law in Government Code section 86205. Question 10, the prohibitions on specified lobbyist activities apply equally to legislative and administrative actions. That's true. These prohibitions apply to lobbying the legislature as well as state agencies while they are engaged in their rulemaking activities. Question 11. A person representing any church or religious society is exempt from lobbying regulations. That's actually false because the exemption applies when representing a bona fide church or religious society solely for the purpose of protecting the public right to practice the doctrines of the church or religious society. Question 12. The term legislative official in the government code covers all employees of the California State Legislature. And that's false because the word or the phrase, the term legislative official means any employee or consultant of the legislature whose duties are not solely secretarial, clerical, or manual. Question 13. A lobbyist under the Political Reform Act includes uncompensated individuals if they're attempting to influence legislative or administrative action. And that's false because, in addition, the test is that a lobbyist must be compensated at least $2,000 or more in a calendar month in order to require registration. Question 14. Legislative action under the Political Reform Act does not include lobbying the governor on legislation. That's false. Under the PRA, legislative action is defined to also mean the action of the governor in approving or vetoing any bill. And finally, question 15. The phrase influencing legislative action includes the use of information, statistics, studies, or even analyses. And that's true. The term influencing legislative or administrative action means promoting, supporting, influencing, modifying, opposing, or delaying any legislative or administrative action by any means, including but not limited to the provision or use of information, statistics, studies, or analyses.